Hi, and welcome to the Long Island Business Buzz Podcast, the show with real conversations with business owners and professionals to learn what it really takes to do what they do. I'm your host, Katie McKnight, and today we are talking about something that affects more people than you'd think, and that is personal injury law. We've got a special guest joining us, Kyle McLaughlin, a seasoned personal injury attorney who's been practicing for over 5 years and has seen a lot. From car accidents to dog bites to medical malpractice, he's handled it all. We're going to get into how these cases work, the tricks insurance companies use, and what you need to do if you ever find yourself in an accident. So, Kyle, thank you so much for being here.
Thank you for having me, Katie.
So, tell us a little bit about yourself.
Sure. I am a personal injury attorney. I represent plaintiffs. I'm in personal injury cases. I'm an attorney at Matthew Salimbene, PC. Our office is in New York City, above Grand Central Station. We represent, people who have been injured in accidents, throughout Long Island, all of New York State, and even New Jersey. Um, I am 31. I graduated from Toro Law School in 2019 and have been practicing mostly plaintiff's personal injury ever since.
All right, fantastic. So I heard a little birdie told me that you weren't always set on being a personal injury attorney. Is that right?
That is correct. I actually was more interested in, I've always been interested in the legal field or in law in and of itself, but thought that I wanted to maybe be more out in the field, be on my feet more. Maybe a federal agent or some type of detective. Um, that was what I had pictured myself being when I was younger. But then when I was in college at University of Maryland, I took a few law classes there, and those law classes just clicked for me. It made sense reading a case and being able to digest a case, and how the case would sway on some of the facts just really clicked in my head that in a way that most subjects didn't. Um, Also, my dad is a personal injury defense attorney. He is hired by insurance companies when there's an accident to defend the person who's being sued. So as a teenager, I would go into his office to strip files or file paperwork for him. And I ended up reading the paperwork more than I would, be doing the work. And he would always yell at me, and I would just end up reading the depositions, the different kind of strategy documents, more so than I would be filing the paperwork. So I knew I was interested, you know, in the law, and I specifically knew that I was interested in the personal injury field at a pretty early age. Um, and something that stuck with me when I was in law school and kind of making the decision on, what field I wanted to be in was I vividly remember my dad coming home from work and us sitting down at dinner and having conversations about, his work. And when he would have a good day at work, he would, kind of sigh and say something like, I just saved $1 billion insurance company some money on a good day. That was a good result for him. And, I really wanted to be on the other side of the case where if I have a good day, I am, getting a person who was injured in an accident, compensation for their injuries, for their pain and suffering. I wanted to work for the little guy going against the insurance companies as opposed to working for the insurance companies themselves.
So I have to ask you. So they say that when family gatherings or at family gatherings, that you should not discuss politics nor religion. Are you able to discuss work when you're with your dad?
We discuss work all the time. And not always in a bad way. Sometimes we joke about, defense attorneys being a little shady or plaintiff's attorneys being ambulance chasers, things of that sort. But we run ideas by each other all the time. We discuss case strategy. We talk about, judges who we've been in front of, the other one's going to be in front of. We talk pick each other's brains kind of all the time about the field and the cases and the judges and everything in between.
Well, that's great. It really is, and it's cool how it's a full. Okay, it's so cool how it's a full circle moment. Now that you've been doing this for over 5 years, what kind of cases are you seeing most often?
Sure. So our firm handles all different kinds of personal injury cases. Those range from car accident cases to slip and trip and falls, a slip and fall on ice or trip and fall on a sidewalk defect or defective stairway or anything like that. Construction accidents, dog bites, negligent security cases, and medical malpractice. I would say that the majority of the cases that we have at the firm are car accidents just because they're more common and more prevalent. But if you've been injured and it's someone else's fault, and there's an insurance policy in play that would cover it, then we are at least having a discussion about your potential case.
All right, which brings me to the next question. For someone who's never been through this before, what qualifies as a personal injury case?
So this is a great question, and I get this a lot. What qualifies as a potential personal injury case, really are three different components. You need all three of these in this chain in order to have a successful personal injury case. The first thing is you need to have a different party responsible for causing the accident or causing your injuries. It's called liability in the legal term or in the field. We need to prove that someone else was at fault for causing the accident or being responsible for the accident. The second chain in the link is damages. You need to have been injured in order to recover for your pain and suffering or to have a personal injury case. It's in the name of the field. You need to be injured in order to have a personal injury case. And the final chain, which sometimes gets overlooked, there needs to be an insurance policy. In the majority of cases, the person or how our clients get paid is from the insurance company who is insuring the responsible party. And you need to have all three of these links in order to have a successful personal injury case. I often give the example of, if you're in a car accident and it's a horrible accident, you have numerous broken bones, you need to have surgery, right? Really bad damages, really bad injuries. But the accident was, mostly, if not entirely, your fault. You don't have a successful personal injury case because there is not someone else to hold responsible for the accident. It was your fault. But in the contrast, if, you are rear-ended in a car accident case, a rear end is the closest thing to a slam dunk in our industry. There's a presumption of negligence on the rear-ending vehicle or the vehicle that does the rear ending. If you're rear-ended, and let's say it's even a bad accident, a bad crash, the cars are smashed up, the pictures are kind of, take your breath away, but you walk away without a scratch, you're not injured at all, you don't have a personal injury case. There's nothing we can really do for you. Go play the lottery or something, or thank God that you're not injured. But there needs to be a party or person responsible for causing the accident. You need to have been injured. And there needs to be some sort of insurance policy in play who will eventually foot the bill for the person's fault.
Okay. So that's hard when someone hits you who is not insured.
That is, that's actually something that I would love to take some time to talk about is you can protect yourself in these types of cases when you're hit by someone who either doesn't have any insurance at all or who has the state minimum insurance, which is $25,000, which, these days, minor injuries can be valued at $25,000. And how you protect yourself in these types of cases is you get an insurance policy that has the additional coverage of uninsured motorist or supplemental underinsured motorist coverage. It's a separate coverage that you can get on your car insurance policy, which protects you in the case of, you're hit by someone who's not insured, you're hit by someone who has the minimum insurance policy or a low insurance policy, and your value of your case, your injuries greatly exceed that policy, or in the case of a hit and run. I mean, we have many hit and runs that we handle where, thank God, our clients have this coverage available to them and they're able to get money from their own insurance company in order to pay for their pain and suffering. I talk about this a lot, and I really stress it. 12.5% of the cars in New York State are driving without any proper insurance. And you're hit by one of those cars and you don't have this coverage on your policy and you're injured, pardon my French, but you're SOL. There's nothing a whole lot, there's not a lot that we can do for you in that case.
Wow. That's great information. That is excellent information. My son was hit a couple of years ago. Thankfully, he wasn't hurt, but he was hit by an uninsured driver.
Yeah, it happens more often than you think. And you can even use this coverage if you are out on a walk and hit by someone who either is uninsured. It protects people in the household as well. It protects passengers who are in your car. It protects your kids, your spouse. So it's really important that you at least look into having that coverage and trying to, have the policy limits of that coverage be relatively high because it's your one safety net that kind of protects you in the case of a car accident, which is really why you have insurance in the first place.
That's excellent information. All right, so let's say someone is in an accident. What is the first thing that they should do?
So it all depends on what kind of accident. Let's start with a car accident and then kind of work from there. In a car accident, you should document everything, and that goes for all different types of accidents. Document everything right away. Take pictures and videos of everything. If you're able to at the scene, you're able to get out of your vehicle, you're able to kind of walk around, and I know you're not always able to, but if you are, take pictures of the damage to the vehicles, where the vehicles ended up after the collision, if there's any markings on the roadway, turn signals kind of on the roadway or turn arrows on the roadway. Take pictures of that. Take pictures of, the roadways themselves, the intersection. If there's a light sequence or at a traffic light, take pictures or videos of that. Take pictures of the other car who hit you's license plate. Get their driver's information. Get their insurance information. Car police in the boroughs of New York City don't always respond to a car accident unless there's some serious injuries or serious damage. So, I mean, you should call the police after an accident, but if you're in the boroughs and you are able to kind of walk away from the accident, their police aren't always going to come. That doesn't mean you're not injured or you might not be realize that you're injured a few days after the accident. So having the person who hit you information is vital, or else we're hit in that scenario where you don't have the person's information. You have to, go after your own insurance if you have that or SUM coverage. It also, what I need to stress, because I actually had a consult about this today, if you're in a slip and fall type of accident, you have to document what caused you to fall, especially if the condition that caused you to fall is legally it's called transient, or it might not be there tomorrow when you go back to the scene. If it's ice on the ground, if it's a puddle, if it's something that's kind of spilt in the aisle of a supermarket, it's not going to be there tomorrow when you go back to take pictures of it after you had some time to think about it. It's going to be cleaned up. The ice might be melted. And we need to prove that not only that you fell, but that something caused you to fall. And these pictures are really, worth 1,000 words, and can make or break your case. So take pictures of everything, and lastly, or second to last thing is if you have a accident in a store, in a building, somewhere where you can report the incident to the company, to the business, you want to do that so you can document it kind of right away, and put the business on notice that, hey, I had a fall here. I don't know how I feel. I fell on this liquid substance in the aisle. It could be documented by the company right away, and you have that incident report that can later be used as evidence. And finally, and just as important as all the other steps, if you're injured in any way, you need to get medical treatment. You need to see doctors because a delay in treatment, the insurance companies and defense attorneys are going to use that against you. They're going to say, you're not really that injured because you waited 2 weeks in order to go see a doctor. And if you are injured in those first couple of days after the accident, you really need to see a doctor as soon as possible and start. And you kill two birds with one stone with that. You document it. You are seeing a doctor and getting treatment by a doctor, you're also getting diagnosed with what's bothering you or what's causing you pain, and you can start the treatment process to feel better at the end of the day.
All right. And I'm sure that a lot of people skip those very important steps, whether it's a car accident, a trip and fall. It's always a traumatic event. I know as a parent, or even an accident victim, the last thing we're thinking is gathering info for your lawsuit.
Yeah, I had a consult today where a former client called me up. She had a trip and fall down a or slip and fall down a staircase in New York City, and she said she slipped on something, but doesn't know what she slipped on and didn't take any pictures of it. I mean, we were still in the investigation process of trying to see if, maybe there was something leaking from the ceiling, or if this is in an area where water kind of puddles when it's raining, like it was earlier today. But without pictures, it's going to be very tough to kind of prove that there was some sort of defect there or something that caused her to slip and fall, as opposed to her just kind of tripping over her own 2 feet.
Right. Yeah, no. My father was recently in an accident. I sound like everybody in my family is in accidents. Knock on wood. So far, it's been minor. So my father was in an accident recently, and he was on the phone with the insurance company before he even arrived at the scene. So, like I said, he wasn't hurt, but he was afraid if he did not immediately get in touch with the insurance company, that he was going to be in trouble. So let's talk about those insurance companies. What are some of the tactics they use to minimize payouts? And is it true if you do not contact an insurance company immediately that you're going to have a problem?
So that's false. To answer your question, you do not need to contact an insurance company immediately after the accident to report it. Um, the timeline, the time frame that you should report an accident to your own insurance company is within 30 days of the accident. You do this especially after a car accident because within those 30 days you need to start what's called a no fault claim. A no fault claim is a claim under your own insurance company that sets up your benefits to pay for your medical treatment. The timeline for that is typically 30 days after the accident. So you don't need to be on the phone with your insurance company, the day of the accident, the day after the accident, or a week after the accident. And contrary to popular belief, you never need to speak with the adverse insurance company or the insurance company of the other vehicle involved in the accident. I had clients, and I mentioned this at our most recent meeting. I have a car accident case that came into the firm a few weeks ago where three siblings are in a vehicle that's rear-ended by another vehicle. The insurance company of the adverse vehicle, the vehicle that rear-ended them, started calling them all up shortly after the accident. And these are clients who don't have the highest levels of education. They don't speak English, isn't their first language. And the insurance company of the car who hit them started offering them $500 in order to, in their words, sign a piece of paper. That's what they believe that they were doing. They were just signing a piece of paper in exchange for $500. Well, this piece of paper that, the insurance company asked them to sign released the insurance company and their insured, the car that hit them, from any liability or the potential to pursue a claim in the future. So insurance companies use this tactic very, very often, trying to minimize their risk by offering a little bit of money in the very beginning. So that down the road, if they find out, or if you find out your injuries were that bad, that you can't pursue an action against them. In my example that I just gave, two of the three siblings signed those papers. We're not able to pursue a case for them. And it's a real shame because they didn't know what they were signing. One of the siblings who was, English he was a little better at speaking English than his siblings, told the insurance company when he was on the phone with them that they don't speak English, don't speak with them. Obviously the insurance company didn't follow that. They signed this paperwork in exchange for $500, and now, I can't represent them to potentially get them tens, hundreds, if not thousands more than that $500 that they ended up receiving. And it's a shame. I've had cases where, $500 is being offered. I had one case that I settled recently where the client called me after the insurance company offered the $500. Thank God he didn't sign the paperwork. And 2 years after he hired me as his attorney, we settled his case for $95,000.
No.
So, he could have gotten $500 a month after the accident. And, we settled his case for $95,000. Um, and it's remarkable how many people sign those documents without speaking to an attorney or kind of looking into their rights.
Right. So basically, these insurance companies are trained to play hardball from day one.
They're trained to play hardball. They're trained to put into your mind that your injuries don't have value or that maybe you were at fault for causing the accident. One other tactic that they use in the beginning is they ask you for a recorded statement. They say, can you give us a recorded statement about how the accident occurred and how you're doing now? And they might even threaten that, if you don't do this, you're going to deny coverage or deny your claim. That you don't have to give that statement, and you should never give that statement, because it's like they say in criminal cases, anything you say can and will be used against you in a personal injury case. And if you give any inclination in that statement that you're not sure how the accident occurred, or maybe you were partially at fault, or maybe you're in that moment when you're giving that statement, you're feeling okay, but the next day you're not feeling okay. If you say in the statement you're doing all right, then it's going to be used against you. And the insurance companies pressure you to give these statements right after the accident, and if you hire an attorney, they're going to put a stop to that immediately.
So basically, the end result is never go at it alone.
You never, ever, ever go at it alone.
Well, this is great information. Kyle, what kind of compensation can someone expect in a personal injury case?
So when we pursue a claim for a client, we can get them financial compensation for numerous different avenues or numerous different pots, as we call it. The main one being pain and suffering. That's, the one everyone thinks about when they're injured in an accident and, they have pain from their injuries. But what they might not know is that we can get what's called past pain and suffering, which is from the date of the accident up until, whenever the case settles, but also take into mind future pain and suffering. If you're still having lingering effects of the injuries, a year, 2, 3 years down the road after the accident, we can factor that into our evaluation and tell the insurance company, tell the defense attorney that these injuries are permanent. They're not getting any better. Maybe our clients have learned how to deal with it over the last couple of years, but they still have restrictions and limitations in their lives because of these injuries. And we can value the case and get them future pain and suffering as well. We can get them lost wages. If, you weren't able to work right after an accident because of your injuries and you lost out on income as a result of that, we can get them lost wages. We can also get them loss of future earnings, which is from if you're not able to perform the same duties at your job and you've had to take a pay cut because of that. At your or at your job, you were on your feet, stocking shelves, and now you have to sit behind a register and be a cashier, and your wages decreased because of that. We can calculate that out and get loss of future earnings. If you weren't ever able to return to work because of your injuries, that figure can be pretty high. So we can get them pain and suffering, lost wages, also medical bills. If you paid out of pocket for any medical expenses or any real expenses related to the case or your injuries, we can add that on to the value of the case and what we're able to put in your pocket at the end of the day. I've had conversations with clients recently about these different, figures or ways we value the case. These aren't, when you settle a case, these aren't going to be line itemed out. You're not going to get a certain number for pain and suffering, a certain number for lost wages, a certain number for medical bills. It's going to be a lump sum settlement where we know as your lawyers what these figures are in our head, and that's how we negotiate your case. But at trial, they will kind of be item lined out, where you see past pain and suffering, future pain and suffering, lost wages, loss of future earnings, medical bills. One thing that also we factor in is future medical care for related to the injuries you had in the accident. If you're receiving physical therapy or chiropractic treatment kind of as a maintenance in order so your injuries don't get worse and you feel some temporary relief, on a monthly basis or maybe once every other week at the time of the case is settled or we go to trial, we can factor that into our valuation as well. So it's the large buckets that we could recover for you are pain and suffering, lost wages, and medical bills, but it's a little more nuanced than that when you really dive deep into it.
All right. So that is excellent information. And I know that we have already spoken about taking pictures of the scene, whether it's a car accident, whether it's a slip and fall, what to be careful with when you are dealing with the insurance company for the other party. At what point should someone reach out to an attorney?
So the sooner the better, you know, maybe not right from the scene of an accident, but once you kind of are able to and come down from the adrenaline rush of being in an accident, and maybe you went to the hospital after the scene of the or from the scene of the accident, and once you get back home, you know, your doctors should be your first call after an accident after you're injured. A lawyer should be your second because the insurance companies start to do those tactics right away. And if you speak with an insurance company or you delay in treatment or you maybe accidentally delete the photographs that you took at the scene or something like that, it could all harbor your case down the line and really, make my job as your attorney more difficult. So, a day or two or maybe a week after the accident, if you've been injured and you don't know where to turn to, you don't know who's going to cover your medical bills or anything like that, you're out of work and you don't know, how you're going to get paid and cover the bills, definitely speak with an attorney kind of as soon as possible.
Okay. So now let's talk about your firm. What makes you different?
What makes our firm different? So we are a boutique law firm, and what that means is we are smaller in size and we only do personal injury cases. We only represent people who have been injured in an accident. We do not do real estate law closings. We don't do criminal defense. We don't do landlord tenant law or business law or anything like that. We only do personal injury law. And because we are a smaller firm, we are very selective on the cases that we take and we choose the cases that we choose to have at our firm because we give those cases kind of our undivided attention and maximize their value. We also handle all aspects of a case, kind of from inception, when the claim is just starting right after the accident, up to and through a trial. We are a trial and litigation and trial focused firm. We are not afraid to litigate a case. We are not afraid to go to trial in order to get fair compensation for our clients. And sometimes it takes that. Now, I've tried several cases to verdict in my career. My boss has probably tried, 15 to 20 cases to verdict in his career. We are ready, willing, and able to litigate a case and to try a case in order to get the best results for our client. And not every firm can say that, or if they do, they don't always mean it. Something else that I think sets us apart a little bit is that we don't advertise at all. You won't see my firm on billboards when you're driving through the city. You won't see us on commercials late at night. You won't see us kind of sponsoring, sports teams or anything like that. We get our clients by word of mouth through people in the field or in the industry who know us, know our reputation, and know how much dedication we have to our clients. We love to get referrals from former clients who we've gotten good results for and are happy with our services, who refer us to their friends, their family members when they've been injured in an accident. And that's, the main way that we get clients and get cases is through that referral source of our former clients.
That's great. And I think that I've heard that some of those big companies that they sort of just view their clients as a number. I wouldn't want my doctor to view me as a chart number, and I wouldn't want my lawyer to view me as a case number.
We don't have file numbers at our firm. Between me and my boss and our case, we can tell you every client's name, their injuries, what happened to them, their type of accident, their little bit of background. We can do all that, just by going through our cases and looking at our clients' names. We don't have file numbers. We don't refer to cases or clients as file numbers. Everything is much more personal at our firm than at some of the larger, more recognizable firms that you see out there.
Yeah, so that's good. So now everybody knows you don't want to go to Google looking for that company with a jingle that you know. So, are there time limits for filing a case?
There are. Um, There are different time limits depending on the type of case. The strictest or quickest one after an accident is whenever a municipality is involved. And by that I mean it can mean many different things, right? If you're in a car accident with a police vehicle or fire department vehicle, a United States Postal Service vehicle, a dump truck, or a highway patrol vehicle, a snow plow, a garbage truck, or if you had a slip and fall at a municipal library or a school that is run by a municipality, um, the subways, the trains, all those different um, things that are at an airport. These are all run by the Port Authority or the MTA. These are all municipal run companies. When you have a case where a municipality is a potential defendant, you have to file what's called a notice of claim within 90 days of the act. This is to put the municipality on notice of a potential claim. You know, that is a pretty strict statute or limitation. There are a few instances where we might be able to petition the court to extend that 90 days or where we allow us to file a notice of claim late, but it's few and far between. And that's the quickest is the 90 days where a municipality is involved. The standard statute of limitations in the majority of personal injury cases is 3 years from the date of the accident. The only exception to that is a medical malpractice case where you have 2.5 years from the date of the malpractice, or then you figure out that your doctor may have committed malpractice in order to file a claim or start a lawsuit actually against that doctor.
Okay. All right, great. All right, so here's my next question. How long does a personal injury case take from start to finish?
This is what every potential client wants to know in our first phone conversation. And I hate to give the typical lawyer answer, but the real answer is it depends.
Mhm.
It depends on so many different variables that it's impossible for me to give you an accurate answer, especially in the first conversation with a potential client. It depends on the type of case that it is. It depends on who the defendants are. Depends on who the insurance companies are. Depends on where the case is venued, which is, are we starting a lawsuit in, the Bronx where there are thousands upon thousands of cases, or are we starting a lawsuit in Westchester County where there's less, or Ulster County where there's less, and those cases are usually moved a little bit quicker. It depends on how injured you are and how long you need to treat for. Sometimes clients don't get surgeries until for a year or two after the accident because their more conservative medical treatment has failed them. They don't get relief from the chiropractor or physical therapy, so they have to do the last resort, which is surgery. The amount of insurance that's in play, the insurance policy also factors into how long a case is going to take until it's resolved. No insurance company is going to pay you $100,000, $500,000, $1 million a month after the accident occurred, unless there are kind of extreme circumstances that warrant that. They're going to make you prove your case, and me as your attorney prove your case and fight for you in order to get those figures. So, I mean, in rare circumstances, the case might be able to be resolved in the first 6 months after the accident, but in most cases, you know, 2 to 4 years is the typical timeline, maybe even longer when a municipality is involved, because, the municipalities just are slow with their discovery. I don't think it's a tactic, but they are just slow to respond. They're slow to have depositions, and they get a little more leeway in the courts with the judges because they are a municipality. So if your municipality is a defendant, maybe 3 to 5 years, a standard kind of slip and fall or car accident case, 2 to 4, is a general timeline of how long it might take. Some a little bit shorter, some a little bit longer.
Yeah, everybody's always looking for that end answer right away, and you're right. There's a lot involved in it.
When clients call me up, they always ask me, how long is my case going to take and what is it worth? And those are the two answers that I really can't give in the very beginning because there's just I don't know enough in order to give anything close to an accurate answer. And any attorney who does give answers to that in an initial conversation is full of baloney and is a red flag kind of right away. Any attorney who tells you, oh, this case is worth $100,000 or I can guarantee you, $50,000 in the first phone call with a client is blowing smoke up your behind in order to try to get you as a client. And, we don't do that. I'm very transparent with my clients in the first phone call. I don't know how much your case is worth. I think it's worth something, or else I wouldn't be signing you up as a potential client or signing you up as a client and investing my resources and my time into representing you. But I can't give you even an accurate ballpark figure of what it's worth at this time. Same thing with the time of how long it's going to take. That's the number one question I get in the initial phone calls or consultations, and it's it's frustrating when the clients really want those answers and you're just not able to give them to them.
Right. Yeah, no, I agree. I agree. All right. So you've given excellent information, and I think that people already know that they should call an attorney. But let's drive it home. Why should an attorney handle your matter instead of you doing it on your own?
Because if you handle it on your own and you've never handled a personal injury claim or a lawsuit, you don't know all the ins and outs of it. These insurance adjusters who you will be speaking with, if you try to handle it on your own, are trained professionals in the similar way that lawyers are trained. They handle hundreds of cases each year, and they're trained on how to diminish the value of the case, reduce the value of the case, and the amount of money the insurance company needs to pay at the end of the day. That's what they're trained on. When you hire an experienced attorney, not only are they experienced, hopefully in this field, the personal injury field, and they know the procedures in court when a lawsuit is started, but they know the value of the case. A lot of people don't know the value of a broken arm, the value of a herniated disc in your neck or your lower back, the value of a back surgery. You know, an experienced personal injury lawyer can accurately evaluate your case and can deal with the insurance companies directly and negotiate with them directly and can help give advice on how to maximize the value of the case. Something else that is not really thought of is it takes it completely off our clients' shoulders. Dealing with a personal injury claim can be a big headache if you try to go at it yourself. You have to, correspond with the insurance company. You have to get the medical treatment in order to get better and to use as medical evidence for the value of your case. You have to, send insurance companies letters, be on phone calls with them, negotiate with them. If you hire an attorney, they will do all of that for you. What I tell my clients when they sign on with us and we hire or we take on their case, your only worry is getting treatment and getting better. We handle everything else. And I get some pushback sometimes about our fees. Um, you know, not every, but the majority of personal injury cases or personal injury lawyers in New York, fees are structured the same way. The firm gets paid when the case is resolved, and the firm's fee is a third of whatever they are eventually able to recover for a client. And I get pushback sometimes from potential clients saying, that's potentially a lot of money. Why can't I just do it by myself and get 100% of, what is being offered by the insurance company? And my response to that is, it is potentially a lot of money. And if it is a lot of money, it's going to be even more work. We'll be working on your case for 2 to 3 years, almost every day for 2 to 3 years. So when you average it out to the amount of hours that we put into your case, it's, really not that high of a fee or that high amount of money. I also tell them that you don't know if what the insurance company is offering you is fair compensation. We as experienced attorneys do. So you might think that the insurance company's offer of $5,000 is fair for your injuries, where if you hire an experienced attorney, maybe they could get you $500,000. They could settle a case for $500,000. And one thing that I actually learned from watching Shark Tank is this phrase I'm about to say. 66% of a watermelon is better than 100% of a grape. Yeah, if you settle that case for $5,000 by yourself, you'll be able to keep 100% of that $5,000. If we settle the case for you at $500,000 or $500,000, you're walking away with, 300 and change in your pocket tax free at the end of the day. Would you rather have 100% of $5,000 or 66% of $500,000?
Right. No, it's true. It's true. It's in the world now where everybody thinks they can do everything on Google or now AI, and they just don't realize how important it is to have you in their corner. So here's another thing that I know a lot of people struggle with. Everybody's afraid to call an attorney because they're afraid that they're going to have to pay you for a consultation. How do you handle when people come and they do a consult with you?
Sure. So I can't talk as the different fields of the law and how other lawyers handle it, but our firm not only offers free consultations, you can speak with us about your potential case for free, but it's free to hire us. You don't, in the majority of cases, you don't pay us a dime out of your pocket while we are working on your case. You don't pay us by the hour. You don't pay us for the case expenses, as the case is incurring expenses, getting the medical records, filing paperwork with the court, doing depositions. These are expenses, that the firm will pay for. The firm gets reimbursed for that out of this potential settlement, at the end of the day, but you don't pay us any of that out of your own pocket. Our fee is a percentage of what we are able to recover for a client. And I think that that's actually a great way to kind of structure it because it aligns our interests with our clients. We are trying to get our clients as much money as possible. So the client walks away with as much money as they can in their pocket at the end of the day, and the firm makes the most amount of money as possible as well. So not only do you not pay us for a consultation, you don't pay us at all out of your own pocket, directly out of your own pocket, um, at any point in time. And our fee is a percentage of what we're able to recover for our clients at the end of the day.
Yeah, you have given solid advice to everybody. Thank you so much for being here and for sharing your expertise. Now, if people want to reach out to you, which they should, or if they want to learn more, how can they find you?
Well, thank you for having me, Katie. It's been a pleasure. This is my first podcast ever, so I hope it went well. If
Wonderful.
anyone, if anyone is interested in speaking with me about anything that I discussed here tonight, or what they heard, or want to discuss a potential consultation, they could find me. My Instagram is Kyle the Lawyer. I have a website, kyleTheLawyer.com. You can also check out my firm's website, which is SalimbeneLaw.com. And on that website, you have, both the websites, you have my email addresses, my direct phone numbers. You can DM me on any of the socials on Instagram. Kyle the Lawyer is my tag on Insta and Facebook.
Great. And every podcast has show notes. So in the show notes, I will absolutely list all that information for you. Before that, we end this podcast today, is there any other advice that you wish to share with our listeners that we have not already touched on?
The only thing that I can think of, and we touched on it a little bit, is it's always worth it to speak with an attorney. I will talk to anyone about any potential case and at least do the due diligence in the beginning to see if it's something we can handle for them. And I'll be honest with a client if I don't think it's worth it, or I don't think they have a potential case, or it's not something worth pursuing. But it doesn't cost a client or a potential client anything to pick up the phone and to call an experienced personal injury attorney. And it could really benefit them financially and peace of mind wise in the long run, much better than if they go at it alone or if they choose not to pursue anything, in the first place. So pick up the phone, call. You don't need to call me if you want to. That's great. But call an experienced personal injury attorney if you have, a potential case because it's worth it. If it wasn't worth it, our field wouldn't exist.
All right. Well, thank you so much again, Kyle. And to our listeners, Kyle provided fantastic information today. Be sure to share this episode with your family and friends. And if you enjoyed this episode, please leave us a review. We'll see you next time on the Long Island Business Buzz podcast. Have a great day.